All right, we are now recording.
All right. Good evening, everyone. How is everyone all the way out in Williamson County today? Good. All right. Good.
Jumping up and down.
Okay. So thank you all for having me speak tonight. I'm sorry I couldn't be there in person. And as Matt said and as Megan said, please feel free to ask questions. I can't see you raise your hand, so there might be a little bit of a delay on that, but I'm more than happy to answer any questions. So my name is Lacey Johnston. I am the lecturer in the Animal Science Department. My main focus is in equine. I have a master's in equine science and education and took several law and liability courses throughout my studies at MTSU. And then also I'm on a day-to-day interaction with the public and with some of our legal things that we've dealt with as far as the equine and different things that I'm a part of. Also a specialist in the U.S. Army Reserve, so that's just kind of a fun fact about me. So we'll go ahead and get started talking about the things that you guys are more interested in, and that's the law and liability aspect. So a couple of things that we'll talk about this evening. We're going to talk about everything from two main aspects. So we'll talk about how this will affect you if you go into business and have equines on your property, or you have some service-based business, whether that be breeding facility, training facility, riding lesson facility, or if this is something that you just have horses on your property and someone decides that you have a very pretty pony that they should feed carrots to and winds up feeding their finger instead of a carrot to. So we'll talk about a couple of different aspects there. First and foremost, we always think of, being responsible and having that privilege of involvement with horses in the industry. And then the responsibility that, lies with us as either a service provider or just by simply having horses on our property. It's really important for us to have knowledge of the laws, the rules, the regulations, and then also it's your responsibility to learn about how things change, what things change, and really, the importance of staying on top of that information yourself. So the first thing that we usually think about when we think about law and liability and we think about some of the different ways that laws would go into effect, you have to ask, do you have horses on your farm as a hobby, recreational, or is this actually a business? So we think of things like riding or leasing horses. If you have horses for buy or for sell or that you're trading, or even horses that you're purchasing to bring onto your property, maybe to have a riding program or to lease to someone else. How you maintain that boarding facility, training facility, lesson facility, how you designate that for your property. And then it's also important with that to contemplate the nature of involvement. So regardless of if it's a hobby or a business, you should always have a plan and always have a budget. So we always think about things along those lines. If it's a hobby, obviously it is for fun. So there are lots of different decisions to make. How many horses can you support? What kind of care will they need? Are there different disciplines that you're interested in? Tack, what kind of participation will you have, the nature of that participation, what would be the nature of participation if you invite someone over to your facility, even if it's just your farm, your personal barn, just to have someone, to ride with and something happens to that person on your property. Also, the location can play a factor in what types of laws could be enforced. Facility, do you have your horse at your house? Are you taking a friend or, having someone come to potentially purchase a horse that you own at a boarding facility? And then kind of what some future options might be as far as how you may view, if it's a hobby versus a business. All right, business is obviously involvement to make money. So typically, if you are running a business, you would have different levels of duty of care, of liability, things like that we'll talk about throughout the course of this presentation. You have to choose the type of entity that you're going to be. So we'll talk about each of those different types of entities and kind of the role that they play briefly in the equine industry. Having a business plan with an overview, an operational plan, marketing plan, management plan, financial plan, exit strategy, all of those things are very, very important because at the end of the day, you don't need to go into anything without a plan. Insurance is probably going to be one of the biggest questions that I typically get when regarding law and liability. What does my insurance cover? What does it not cover? Do I need additional insurance if I am teaching riding lessons on someone else's property? My biggest suggestion is always, always have more insurance coverage than you necessarily think that you need. I will say I am not an attorney. I'm not a lawyer. So legal advice from someone in your local area, at minimum in your state, is very, very, very important. I have a friend whose husband is an attorney in Mississippi. And so I modeled my farm's liability release waiver after their farms because obviously being that he was an attorney, it was pretty ironclad. But as I was reading through it and looking back through it, I realized that some of the things did not apply to us here in Tennessee, and it was verbiage and wording specifically for the state of Mississippi. So you have to be cognizant or be aware of that and make sure that that legal advice that you're seeking is going to be applicable to your area or will pertain to, whatever the facility that you do have is. We'll talk briefly about the 5 major types of business entities. We have sole proprietorships, partnerships, limited liability companies or LLCs, and then S corporations or just your traditional corporation. So a little bit more on the boring side probably, but we'll go through this and kind of discuss some of the different aspects of it. So sole proprietorships are really the most common and the simplest because that person owns the entire facility, entire company, the entire entity, and has absolute control. However, you do have sole liability. So there is no division of liability in a sole proprietorship. Income tax and self-employment taxes can be applicable. And you do have to report income even if there's no money received. So even if that's a zero balance, on the dollar line, then you still do have to report that. We also have partnerships, and partnerships are 2 or more persons engaging in business together. Each person in that partnership is going to contribute resources, and each person has some control. The liability is distributed, and it doesn't have to be 50-50, or if there are 3 people, 33% apiece. You can actually decide amongst yourselves as partners how much liability you would like to assume. And usually the person that assumes the greatest amount of liability would probably see a higher paycheck out of whatever that entity is. Income taxes would be something that you would have to contend with there as far as with the IRS. And then again, even if you don't have any gains or sales, you still do have to report that income, even if it's 0. An LLC, these are one of the newer and trending types of models. All of the owners are called members, and each of those owners share limited liability. Same control as a partnership, so you can even designate, someone is 60-40 or 50-50, or divide that up if there are multiple people. With this level, there are state and federal taxes that would be collected, and the limited liability piece of that, again, really is as far as debts, obligations, or liabilities. So it's not specifically split up based on the number of members that are there. Like you would have a partnership, you can divvy up the control, but it's just a little bit different as far as the liability that would be assumed. We also have corporations, and then we'll talk about S-corps here in just a minute. And these are not typically seen in the equine industry unless it is a very large scale. So if we think of like Tryon or the Kentucky Horse Park, or a very large scale facility, you might think of a corporation set up for that. directors, officers, shareholders, more complexity, more costly, highly regulated, corporate taxation brackets, and then most limited liability to shareholders. So the shareholders are usually not going to be liable for decisions that are made or for anything that happens as a result of the decisions made by the directors or the officers. And then finally, again, another one that we don't typically see in the equine industry is an S corporation. And this is just a variant of the corporation. We still have the shareholders, but the shareholders can be employees. They still are limited in their liability. But then we have the directors and officers as well. And then there's no corporate tax with this. So similar to a partnership, they would have a different tax scale or tax regulation there. All right, so some of the things that we see, and of course all of this will be in the handbooks I think that you all either already have or will be receiving towards the end of the course, but profit motive or for profit is basically what determines if this is a successful business or not. So to prove profit, you have to be able to prove profit 3 out of 5 years in operation or 2 out of 7 years for breeding, showing, training, or racing. So you can see how this applies directly to the equine industry. The IRS will allow for write-offs of losses if it is recognized as a legitimate business. So again, if they can prove profit 3 out of 5 years, and that can be anything from sales, leases, riding lessons, or if it is just 2 out of 7 years for breeding, showing, training, or racing, as stated above. If the business fails to show profit, then the IRS considers 9 separate criteria to determine a profit objective so that they can strive to be a for-profit facility or entity again. There are 9 very detailed criteria, again, that are in that law and liability supplement. So I won't bore you with all of those intricacies. As far as insurance, so I did mention that horse owners or farms may need to have several different types of insurance. And when we think about liability, we think about commercial insurance versus personal insurance. We think about workers' compensation, care, custody, and control, vehicles, automobiles, horse trailers, even farm equipment, and then home or farm owners insurance when we think about fire or flooding. We've had lots of rain lately. So we'll kind of go through each of these briefly. So as far as commercial or personal insurance, it's never a good idea to plan for your homeowners or your personal insurance to cover any situation that could arise on your farm. It is a better plan to have a commercial insurance or some sort of additional kind of padding there, just to make sure that anything that happens, they can't come after your home or anything else. So personally, I have my home and my farm are at the same location. I have mounted archery clinics occasionally here, and so I have separate insurance for my farm, Bob Johnston Farm, and I do not allow that to count towards my homeowner's insurance because that is a nightmare. I mean, just imagine if someone were to fall off and be injured or, something worse happen, they could literally take not only my farm, but my home as well, because that's all considered one location together. Workers' compensation. So this is obviously going to be if you are paying someone, they filled out their 1099 and, that is taxable. Workers' compensation, however, is not designed for, you have someone that comes in and feeds 3 times a week or, cleans stalls for you and you're paying them cash kind of under the table. We don't normally talk about things like that, but workers' compensation would not typically cover someone like that. Care, custody, and control. So that is more along the lines of the horses on your property and making sure that those horses stay on your property. So we'll talk about a case study here in just a little bit with a fence line fiasco and some situations that could directly impact you if you aren't caring for fence lines, maintaining fence lines, if you don't have proper signage posted for areas that people should or should not be at your facility. And then again, automobile, obviously having, your auto insurance up to date, everything that it needs to be. Commercial hauling, now if you accept payment for hauling any animal that is not your own, you're supposed to have a CDL. So that's one of those new rules that just went into effect. It's been really exciting for anyone in the equine industry, unfortunately. And then finally, again, homeowners, farm owners insurance, just make sure that you have an up-to-date policy with adequate coverage for what you do, what you intend to do, and reevaluate that annually, just to make sure that all of those goals align and that you have the most coverage, the most comprehensive coverage that you can. We'll talk about contracts. So contracts, to be binding, must contain a clearly defined offer. You have to prove acceptance of that offer. Intention for both parties to enter into legally binding agreement that is enforceable. And then it has to be supported with valid consideration. So it's always important to have things in writing. And this goes really for a bill of sale. If you're, purchasing a horse, selling a horse, if you have any services that you're providing, especially breeding or training services, you need to have everything outlined in a contract that is easy to understand, that covers all of the bases legally and liability wise for you. And then it's really a good idea if you can have someone that is a third party, completely unrelated, witness that signature, or if you can have it notarized, because there's always the chance that two people come to your facility, everything looks great, they're going to buy a horse, they sign the contract, the one person signs the contract, the other person that is their friend is the witness, and then later on the witness stand, that friend was suddenly, they were under duress because they felt that if they didn't sign that paper, that contract in front of you, that their friend wouldn't be able to buy the horse. So people are interesting. Just always think about, the things that could go wrong and have a plan just in case.
Hey, Lacey, quick
Yes,
question.
sir.
What would be a situation in which you would not, necessarily need to have a contract, whether it was riding on your property, boarding, because it's popular in this area, it may be just boarding a friend's horse where you have one horse, or you're allowing them to ride on your property, they trailer over just an afternoon ride. Or is there any way that you would have contracts for any of these kind of simple situations?
So for those situations, I would be more likely to have a release. And so we'll talk about releases next. Contracts would be more for if you're providing a service, or if there is a sale that's occurring, an exchange of money for an animal, or money for breeding opportunity or something like that. So that's really where I would think of a contract. Now, personally, I would have a contract if I was boarding someone's horse, because it's always one of those tricky situations. And I learned the hard way. I boarded one of my friend's horses here on my property. We're still friends, so that's the good part of it. But her horse, she didn't tell me, was very destructive and had no issues with taking down fence lines. And so I didn't have anything in my initial contract stating that it was the owner's responsibility to repair or replace anything that their horse damaged, that then in turn cost me, additional time or money to fix. So that is something that's now in my boarding contract. And I do have two separate contracts. I do have, I have a contract and a release. And we'll talk about the release, and I'll go into more detail about that here in just a moment. But for my boarding contract now, it is very, very outlined on, I have different options as far as, I will provide a stall and stall cleaning services. I will provide, do you accept or decline that I will hold the horse for the farrier or hold the horse for the veterinarian? Do you accept or decline that I provide hay and grain as available to the farm, or do you prefer to feed something yourself? Do you want to get your own hay? Do you want to get your own grain? So there are a lot of different things that I never thought about that are now in that contract. And I just make sure, and I go through it. I go through it line by line. And you have a lot of people that are like, okay, yeah, it's just like every other contract. But I go through every line of it just to make sure that they have a full understanding, rather than someone saying, oh, well, I didn't read that or I didn't see that, so that doesn't count, right? But does that answer your question?
Perfect. Thank you.
Okay. Yes, sir. All right. So next up, we do have releases. And so this is one of the questions that kind of the second part of the question that Matt asked me, and I'll go ahead and kind of go into that. So basically a release screens potential participants. So with that release, you can say, okay, this is the information about working around horses or being around horses. These are this may be a situation that could happen. And you are basically stating that you understand that you are taking on the risks. And we'll talk about inherent risks and all of that here in just a moment. But that you're accepting the inherent risks of working with or around equines that, are large and stomply and flight animals because they're prey animals. So things happen. It may limit the damages that can be collected in a lawsuit, but it cannot prevent someone from being able to sue. So this is where we see situations where, someone comes over to your house, and I have everyone that comes onto my property, whether they are going to be interacting as an equine participant. We'll talk about what that means here in a minute as well. But if they're going to be in my barn, they have to read and sign a release. If a parent brings a minor to my barn, they have to read and sign a release. And then they also have a line that they'll sign for their child. We'll talk about a case study with that a little bit later as well. But it is really important to make sure that it has all the comprehensive information. And I'm happy to send you all a copy of my my boarding contract and my release so that you all can have that and kind of see that. I didn't even think to try and take a screenshot or anything to put that up here. But it's just in general a good idea to have a guideline or a set of rules. On my release, I have my barn rules. So what to do, what not to do when interacting with horses to be safe. I go through that with those people, with anybody. And then I will keep that usually. I have pretty much everyone who's ever come onto my farm still. But if it has been, I usually do every 3 years, I'll have someone just do a new release, because technically after 3 years, they're not good anymore in the state of Tennessee. Some say 3 to 5 years. But I just, every 3 years, I don't even change it unless there's something that needs to be updated. But again, it's just really important to have something in writing that shows that that person at least took the time to somewhat understand what they were doing, what they were interacting in, what they were being a part of. So again, it unfortunately doesn't prevent someone from being able to sue. But if you think of, this is worth the paper it's written on, I'd still rather have a piece of paper with their signature than just me trying to defend myself, in court for whatever reason. So.
Thank you, Lacey. We really appreciate getting that example.
All right. Perfect.
So break us down the Tennessee annotated code sign that we all see on all the equine properties. Is that just a scare tactic, or what does that do to help us?
Nope, that is incredibly important. And once again, you are a mind reader, sir, because I have that broken down word for word here in just a couple of slides.
Perfect. Sorry.
Yes, no, you're fine. You're fine. Those are all things that need to be addressed. So no, I'm excited. We'll talk about that, and I've got it broken down. I have the whole sign, and we'll talk about kind of where those belong. And I've got it broken down as far as what all of the words on that sign mean, because it can be a little bit misleading if you're reading it from different standpoints. But going back just really briefly to releases. So again, with those releases, wording is very, very important. Make sure that someone who practices law in your state and who understands that equine law or the liability law that we'll talk about here in a moment, reviews that prior to you using it. Should be very simple, should be something that anyone can understand. So don't put discipline-specific terms. Try to avoid that. Try and avoid really industry-specific terms in general, something that a layperson wouldn't be able to easily or quickly understand. Some states don't recognize releases or they only enforce it under limited circumstances, but we are very fortunate in the state of Tennessee that our state does recognize releases and will enforce them as long as, again, it's worded properly, it's been reviewed by someone who is familiar with those laws, and that it makes sense. Let's see. Oh, yes. So releases, again, make sure that the signer fully understands the document. Don't just let them scan it and sign it and hand it back to you. Go through it with them. It needs to be clearly labeled as a release. So they need to understand this is a liability release waiver. You are waiving your right to sue me in the event that something happens. It does not protect us, though, from any claims of negligence. I've got a case study on negligence here in just a minute, but always, I'm a firm believer in I double check my lesson kids tack multiple times just to make sure, because you never know when somebody has not tightened the girth all the way. They've grabbed the wrong bridle for the wrong lesson horse. I mean, there are lots of different things that could happen. So I always make sure just to protect myself against any claim of negligence or any claim of, that there was a lack of duty of care. I make sure to check everything. It should name anyone. So if there are any instructors, barn owners, land owners, horse owners, anybody that should be protected in that release needs to be named in that release. So anybody who could be sued needs to have their name on that. And you can just do, so mine has Fob Johnston Farm, in parentheses, owner Lacey Johnston. Now, one thing about releases is that it can only cover foreseeable accidents. So it's not going to cover an act of God, a tree falls in the middle of the riding arena and the horse, rears and dumps the rider. That's not necessarily something that the release would cover. But also, I believe that in a court of law, they would understand that that was a freak accident and then that you didn't, have a band of beavers over there trying to gnaw down a tree so that it would fall at a certain time during your lesson. And then it should be worded, again, to cover accidents that might take place either mounted or unmounted. So, you can be sued over a horse stepping on someone's foot, just like you can be sued for a saddle slipping off during the middle of a lesson. So it's really important to have that wording in there. So we have a case study on this one, and I'm just going to bring all of these points up and then we'll kind of talk about it. So it is very important to realize that children cannot legally sign a binding contract. So there's always this question, of all of our youth riders that the parents are more than happy to get them into lessons. The kiddos are really excited. But there's always that question of, can the parents actually sign the rights of their minor children away? And can they prevent those minors from then seeking damages? Or can one parent sign away the other parent's right to collect damages? So say, mom brings the minor child in for riding lessons every week. Something happens to the child and mom's the only signature on there. But dad wants to sue. So dad in that case could sue because he didn't sign anything saying that he wouldn't. And again, releases may help document that the risks involved in an activity were thoroughly explained to the child. But again, it depends on the child's age. So here's kind of a case in point situation. So in Meyer versus Naperville Manor, There was a 10-year-old girl that was riding a lesson horse. She had been under riding instruction for the past 3 years, but had been advanced pretty quickly through the levels due to her ability. She was riding in an indoor arena with a scary heater in it, and she was riding one of the normal lesson ponies that she was familiar with. And the riding instructor asked her to trot closer to the heater just to help her and that lesson pony kind of get over the lesson pony's issue. Apparently, the lesson pony was being a little fractious at the time. Apparently, the heater came on at that point in time, and the pony bolted, unseating the rider, and that is the polite way to put it, obviously. And so they were so the mother had signed the waiver or the release form, but the child actually in that case said that no, they wanted to sue and that they had a right to sue even though they were a minor. So this is a 10-year-old child. I feel like there was probably some other influence in this situation. But then that Naperville Manor had to prove that they were not negligent and had to prove that there was no propensity for that specific lesson pony to dump riders out of the blue. So it was found by the court in favor of Naperville Manor that it was a recreational activity when that child mounted that pony. They were a team in a recreational activity, and that activity was not protected by the Animal Control Act, which Meyer, they were trying to say that basically the Animal Control Act showed that if an animal showed any propensity for danger or harm or maliciousness, that would have been a way that they could have proven negligence on Naperville Manor's side. So it was found in the defendant's favor in that case. There was another case, and I was trying to find it because I talked to my students about this one, and I thought I'd found it in my notes. But there was a situation where a young girl was, again, a minor. She was 15. She was in a riding lesson. The horse that she was riding, very similar to the situation, became spooked, and she became unseated, wound up breaking her ankle. The parent and the riding instructor agreed that it was a situation that, it was the rider's fault because she was not balanced and she wasn't listening to the instructor at the time. Well, on down the road, statute of limitations expired to where that child should not have been able to sue, but that statute of limitations restarted when that child turned 18, so was no longer a minor. She came back and sued that riding instructor on the basis of her having dreams and aspirations of being a prima ballerina, and that was ruined when her ankle was broken when she was 15 years old and fell off of this person's horse. So now that trainer had to go back through all of their records. This is something that this girl has thought about for several years. Obviously, the trainer has, probably not really given much more thought to it other than that day and the trauma that was involved in that. So even situations like that, you can't sign away a child's rights. So just be aware of that and make sure, especially if you have parents who are really pushing an issue and the children are not really interested in riding, because with that, if the child doesn't want to be there, they might find ways not to be there. So just be aware of that and kind of keep that in the back of your mind.
Lacey, I have a question in the audience.
Sure.
What are thoughts of using online or digital waivers? In our case, it's for a nonprofit.
I don't know if you heard that, but what are your thoughts for using online or digital waivers? And for their case specifically, it's for a nonprofit.
Sure. Those can be just as valuable. They actually have ways that you can do e-signatures now that validate that person having read that content, and that shows that they have to have made it through the document to accept that. My only concern there is make sure that you have a solid way and very reliable way to back those up. just in the event of, a server malfunction or something that might delete those. But yep, there's really nothing against having a digital waiver. I think honestly it saves trees and it saves space as far as having to keep track of those documents. So yeah, that's definitely possible.
Thank you.
You're welcome.
I have another question.
Yes.
I have a contract where the release is minimum contract, the boarding contract, so the release is built into it. But then I also have a standalone release for people that aren't boarding but doing other things. Does that work?
I don't know if you heard that, but
I did. Yes. So she has a boarding contract that has a release in it, and then a separate standalone release. Correct?
correct.
Yes. Okay. And that honestly is more or less what I have for mine. So I have a facility release liability waiver form that's for just anyone that comes onto the property that does not own a horse. And then I have a separate one for my boarding contract, because really whoever is boarding needs to have a full understanding of the release, the liability release waiver and everything that entails. So that is a great idea. I definitely strongly suggest that and support that.
Thank you.
All right. So now we'll just talk a little bit about liability and kind of what that looks like from either a professional, equine professional aspect, or even just having horses present on your property. So we'll talk briefly about civil liability as far as personal injury and property injury. And then we'll also talk briefly about criminal liability and some of the things to consider there. As far as civil liability, so remember some of these words. So we'll talk about these here in just a minute in the Equine Liability Act. But the equine industry activities in general are considered, because of their inherent risks, to be something that generates a number of opportunities for potential civil liability claims for negligence. So negligence is one of those words that are thrown around, and we'll talk about again in another case study here in just a minute. But failure to use reasonable care or perform a duty of care in regard to others or property is usually the biggest reason that someone is found negligible. So we'll talk about inherent risks, and we'll talk about Equine Liability Act for the state of Tennessee a little bit more in depth now. Or, well, actually in just a couple of slides. That's right. We've got criminal liability first. Sorry, I moved some of my slides around a little bit. So we do have criminal liability, and there are state statutes, not statutes that deal with willful intentional acts in violation of statute or common law, things that could result in fine, imprisonment, or both. And it does require proof beyond a reasonable doubt. But things that we think of along these lines would lead us to the three main statutes in the state of Tennessee. So cruelty to animals, which is a misdemeanor. Horse shows, anything that happens at a horse show could be found as a misdemeanor. And then aggravated cruelty to livestock animals, which would be a felony. So these three areas are the ones that we think of that could have criminal applications, or, as far as criminal liability being found as a criminal offense. All right. And then some of the other federal statutes spelled correctly. The Horse Protection Act. So there are several civil and criminal penalties for violators of the Horse Protection Act. Really focused on gated breeds to date, but it's kind of expanding due to some different things that have been brought forth in legislation regarding shoes in general, horseshoes in general. And then obviously that forbids the transport, showing, exhibiting, or selling of store horses, could result in a fine. And then you do have to have proof beyond a reasonable doubt. And that's usually the biggest one that the general public is aware of. However, the other two that were previously mentioned, as far as cruelty to animals and anything that might happen at horse shows, is probably a little bit more common as far as what we deal with. All right, so now here we go, the Equine Liability Act of Tennessee. So basically, it is discussing how, and oh, there we go, there's the sign. So how many of you, and Matt, you'll have to help me out here with a show of hands, and hopefully it's all of you. How many of you are familiar with the Equine Liability Act signs that are what are stated in that second paragraph? Warning, under Tennessee law, an equine professional is not liable for an injury to or death of a participant in equine activities resulting from the inherent risks of equine activities pursuant to Tennessee Code Annotated Title 44, Chapter 20. So how many of you have one of these signs at least on your property?
Looks like a majority.
Majority. All right. So it is something that you definitely want to do, even if you only have pasture ornaments. Even if you have horses that are just kind of hanging out in the front yard, it is a good idea to have one of these warning signs clearly visible in locations, typically near stables, corrals, barns, arenas, any entrance or exit to your facility, even if it is not one that you intend for the public to use. Basically, any way that someone could come onto your property and get near a horse. I have this in my barn. I have this at both gate entrances to my facility. I have one near our riding area, and that may seem like overkill, but this will protect you and help you quite a bit as long as you have this posted, and you help anyone that is engaging in any equine activities on your farm to understand what all of this means. So in summary, it basically just means that any sponsor, professional, any person related to an equine activity is immune from liability for death or injury of a participant that happened due to inherent risks of equine activities. So it should also be in all of your written contracts. So I have this in my release. I have this in my boarding contract. It's even important if you have a breeding contract. Like I said, anytime anyone could ever potentially come in contact with an equine on your property, they need to have seen this at least once before that happens. So again, a good idea is putting that in those contracts or releases just to make sure and covering it with them. And, you know, most people are going to read it and say, yeah, okay, whatever. But helping them understand it sometimes is a bit of a challenge, but we're going to break that down in different pieces here over the next few slides. So if we, I'm sorry, yes, sir.
Quick question.
I would like to know how this pertains to somebody trespassing or not having permission to come across my pasture.
Very good question, and something we deal with all too often. So, and I'll repeat the question just to make sure, I believe I heard it, but if you have someone who is trespassing or is on your property or coming through your pasture and interacting with those animals, is that correct?
Correct.
Yes. All right. So horses are what we call an attractive nuisance. So that is actually what horses are designated. And an attractive nuisance is basically, and it's really interesting that horses are designated as that, because other things that are designated as attractive nuisances would include, let's see, so like rusty bathtubs or discarded refrigerators or washers or dryers, anything that a child could stumble upon and get stuck in or injured by, old farm machinery. Those are things that for whatever reason attract people, particularly children, and horses fall into that category. So one of the things that will protect you there is if you do have that signage, if you also have a no trespassing sign up, and then also making sure that all areas, all points of access are secure. So I had a situation not too long ago where there was a grandmother and a daughter that would stop by, and I didn't realize it was happening. My neighbor across the street actually called me and let me know. But apparently they were stopping by frequently. It wasn't every day, but maybe, once a week at least. And they would pull into the barn drive and stop at the gate that was closed. And they would get out. And I kept finding all of these wrappers, food wrappers, down by the horses. And I was like, what on earth is happening? Well, apparently they were getting out of their vehicle, luring the horses over to the fence line and feeding them. So I finally caught them doing that and asked them not to do that anymore. And they haven't since. They just, said that they thought the horses looked hungry and it was just a thing that they wanted to do and stop by. And I explained to them why that wasn't a good idea. And I do have a partially blind Appaloosa. And so, luring him over to the fence line is not usually a good idea. So they were very well received about it, but they just saw two horses standing in a field and thought that there was no issue with just stopping and feeding them or trying to pet them or do whatever they wanted. So until that point, I did not have a no trespassing sign. And I also did not have one of the equine law and liability signs. And I posted both of those and I have not had any issues since. So making sure that your fields are not your fields, that your fences are in good repair, that you have fences, or gates closed, in areas that you don't want people to go, but that would not be on you. You would not be liable for any injury sustained by someone trespassing on your property. I have another case study that I don't think I put in here, but there was a lady that was cleaning up trash along the roadside on her property. She crossed the street over by her neighbor's property, and he had a 2-year-old stud colt. Well, she said that he basically ran at the fence and grabbed her and picked her up, and he was vicious and needed to be euthanized and all of this. Well, she crossed over onto their land, was on their property, and basically had been seen kind of antagonizing the horses before. And so that was found in favor of the defendant, or the owner of the stud colt, because she was not supposed to be on their property and they did have no trespassing signs posted. So I would definitely suggest posting a sign, and I would definitely suggest just making sure that things are less accessible. And, sometimes it's not possible. If you have a facility that you don't have a gate that stays closed all the time, then, you can have issues where people might just stop in but still, as long as you have those signs posted, then you wouldn't be liable for that. And I feel like I spent a really long time answering that question. I'm sorry. All right. Does that help?
Yes, thank you very much.
Okay, perfect. All right. So just to briefly kind of break down the Equine Liability Act and what each of those pieces mean, because it is important to understand that. An equine activity sponsor could be anyone that is sponsoring that activity or providing a facility or organizing a facility for people to interact with horses. So any individuals, groups, clubs, corporations, anything that sponsors, organizes, or provides that facility. An equine professional means that that person is engaged for compensation. So typically we think of an equine professional being someone who's giving lessons, someone who is boarding or leasing. But really now it can be just about anyone that is involved in the industry, whether you're accepting money for that or not. You can still make a claim of being an equine professional and still being covered under that Liability Act. Participant is any person, amateur or professional, who engages in an equine activity, whether or not a fee is paid to participate in the activity. So whether it is someone that is coming over and you're teaching them how to groom a horse and they're not paying you anything for that, or they're cleaning stalls, and you're not paying them for that, but it's just something for them to help you with chores or whatever, then that is a participant. That participant does not necessarily have to be on a horse. They don't even have to be near a horse. But if they are, somewhere on an equine property, then we would consider them a participant. Engages in an equine activity is going to be riding, training, assisting in medical treatment. So if you have a horse that is normally very laid back and very easygoing, that is painful, that horse is probably going to be less easygoing and less laid back. And so if that horse were to bite someone or kick someone as a result of medical treatment, they are engaging in an equine activity and you are covered by that liability act. Driving that horse, being a passenger of an equine, so either riding on the horse or in a wheeled vehicle that the horse is pulling, and then any person that's assisting or assisting a participant or show management. So if they are there doing anything horse related, then they are engaging in an equine activity. However, it does not include spectators unless the spectators enter an unauthorized area. So what I usually do is if you have a designated area for spectators to sit and watch, make sure that it is an area that even, a little 5-year-old could not pull a pony into that area, that is a very safe, secure viewing area so that no horses should be able to get into where the spectators or the spectator designated area is. That area also ideally would not be something that would allow them to reach in and interact with horses or riders. So just something to kind of keep in mind for a spectator area. Now, if you have, say you have an open house or a show or something at the barn, and you have it clearly marked that, riders only past this point, and they bring their entire family into the barn, they are now engaging in an equine activity because they are in an unauthorized area. So that's kind of how you can be protected under that. An equine activity, again, shows, fairs, competitions, performances, parades, literally anything that any equine, so horses, donkeys, mules, and any discipline. So it's not specific. Training, teaching, or boarding activities are also covered in equine activity. Riding, inspecting, or evaluating an equine. Rides, trips, or hunts, so trail rides, pack trips. And then placing or replacing horseshoes on an equine. So farriers and veterinarians understand that they have dangerous jobs and they accept the inherent risk. So your farrier and your veterinarian understand that their job is an equine activity, an equine-based activity. So you should not ever be placed in a situation where your veterinarian or your farrier is going to attempt to sue you due to a fractious horse or due to something that happens. As far as inherent risks of equine activities, that basically means, again, horses are large, they're stumpily, and they may or may not be aware of, you standing there if they are spooked, because they are prey animals. They're also herd animals. So if they see their friends, somewhere else and are trying to get to them, there are lots of things that could happen that cause horses to attempt to leave. But again, any of those dangers or conditions that are an integral part of equine activities. And then this is just kind of our long list, but the propensity of a horse to behave in a way that could cause injury, harm, or death to a person or persons around them, unpredictability of their reactions to different things, any kind of hazards like surface or subsurface conditions. So if it's really slick out or icy out, if there's a lot of mud, collisions with other equines or objects. So, heaven forbid you're riding in the arena and one horse takes off and runs into another one. And then the potential of the participant to act in a negligent manner specifically, that could contribute to injury of the participant or others, or injury to the participant or others. So if they basically have a horse that bolts with them or that they are not able to control, that is still considered an inherent risk. Like I said, farriers and veterinarians knowingly and willingly participate in high-risk occupations, and owners are not liable for any injuries that occur in the normal course of their job. So if you're asking them to do, something really outlandish or random, then maybe that could be an issue. But kind of a case in point, unfortunately, my veterinarian's technician, they were out doing a routine farm call, vaccinations, Coggins, no big deal. They had sedated the horse for a dental, very sweet older gelding, and they asked if the owner wanted them to clean his sheath while he was sedated, and they said sure. Well, he moved. He wasn't necessarily trying to kick. He was just readjusting himself under the sedation, and wound up picking his foot up enough while the technician was underneath the horse and actually broke her jaw. But it wasn't anything that the horse was doing to be dangerous or malicious. It was just a complete accident. But that technician cannot sue the veterinarian she works for, nor could she sue the owners of the horse. Owners are obligated, though, to inform anyone of any dangerous propensities the horse might have. So if you know that horse bites or you know that horse kicks, you have got to let people know, because the worst situation is someone on a horse that kicks and not being told, and them getting too close to another rider and causing that rider or that horse damage. You could be liable for that. And then finally, again, farriers, veterinarians are responsible for ensuring that the work area is safe as possible. So if it's a really muddy condition or a poorly lit condition, obviously in an emergency situation for a veterinarian, they're not going to say, no, I can't work in that condition, but they do have the right to refuse service. So just keep that in mind.
We have a question, Lacey, real quick.
Sure, yes.
So if you're the owner, you know the behavior of your horse, and you have others who, I'll say, should know better, that insist on engaging in behaviors that the horse doesn't like, e.g. putting their face up to a horse that's known to be a little nippy. Would the owner be held liable if the horse were to reach out and bite, even though they've been warned?
Yes. So, and I'll repeat the question just to make sure that I understand it fully. So if you have a horse that you know tends to be nippy, if someone puts their face too close, and they've been warned that that horse will respond that way, can the owner be held liable?
Yes.
Is that correct? Okay, perfect. So in that situation, that should not be a gray area, but too often it can be. Because if that person can prove that they knew nothing about the behavior of horses and that they do that to their dog at home all the time, that's one of those kind of situations that they would try and pull. But if you have warned them, if you could even possibly put up a sign maybe on the stall that would say, may bite or may nip. If there's something posted that says, you should be aware of this, you should know this, and then they still interact with that animal in a way that's going to cause them to respond that way, then you should not be able to be held liable for that. I'm sure if they had a really great attorney, they could probably spin it any way that they could. But that's why I always do, even if it's somebody that I know knows horses decently well, I'll have just a quick, these are the horses in the barn. These are some of the peculiarities, and I might even have that on their stall card if they tend to nip or if they, don't like other horses passing too closely to the stall, things like that, because it's really hard to make sure that everybody knows everything. And it's even harder to make sure that everybody is listening when you tell them the different things. So that can be a little bit of a frustration for sure. But in that situation, again, it can be considered a gray area, but if you have, signage posted, or if you know that they have been told multiple times, then that really would be more of their own fault for doing that versus you being liable for having a nippy horse. So, and that was actually one of the arguments that was used in the previous case I was talking about, a lady that walked across the street and was effectively trespassing, was that young horses are known. There's research that shows young male, especially studs, our stallions are typically more mouthy or nippier. And so they were actually able to use that research and prove even more that the defendant was not at fault. So there are lots of things that would be on your side or in your favor for that. But still, if you can protect yourself by even having just a little sign up there that says may bite, it could save you.
Thank you, Lacey.
You're welcome. Yes. All right. And then let's see, propensities. Sorry, we're running a little short on time. I only have a few more slides, probably about 5 more. So known propensities and disclosure. So here we go. So propensity is the tendency of someone or something to behave in a predictable fashion based on past behavior. Sometimes we think about this with the one bite rule and dogs. So, used to, if a dog bit someone, they're going to be quarantined to see if they have rabies. And then that dog is labeled as a biter, is labeled as a vicious animal. Horse owners do have a duty to warn people of a horse's propensity for dangerous behavior. So it sounds like you followed all of those steps that you should by saying, this horse may be nippy. Please don't try and feed your fingers to it, and please don't get into that horse's face. And then the things that we think of that constitute a propensity, that can be the number of episodes or the number of situations that horse has exhibited that behavior previously. But it also is important to teach people the signs of impending bad behavior that they may not notice or that they may not respond to appropriately. So that is where we can take that as an educational moment and say, well, you really probably shouldn't do that because, this horse does have a tendency to bite. And the biggest response I get that's the most frustrating is, oh, he wouldn't do that to me. Well, yes, he probably would, so it's just, sometimes it's difficult to get that information through to someone. But again, breed, gender, use that they might have, whatever they might have been used for, previous training. Sometimes we don't know the horse's background and we don't know what propensities they actually do have. We really think about that with buying and selling horses. So we have another case study, Hall versus Klein, and Hall purchased a 4-H pleasure horse for her daughter, for his daughter from Klein. And they determined the horse to be unsuitable and wanted a refund when the horse, and wanted to return the horse, wanted a refund when the horse reared on the trail ride, unseating Hall's daughter. But it was proven that Klein did not breach duty of care involving the sale of the horse. She did not actively and grossly misrepresent the horse, and that she didn't have any, the horse had no propensities or prior situations where that horse had become dangerous or had, unseated a rider on a trail ride. So that was also found in the defendant's favor, because basically she sold them the horse, she told them what the horse could do, and they decided that they didn't like the horse because of this one incident and tried to seek a refund, which Klein said no, and then the court upheld that. There's strict liability versus assumption of risk versus comparative negligence. And all of this is going to be be affected or impacted by the background, the knowledge, and the experience of the affected parties. There's also negligent entrustment, and negligent entrustment basically states that horse owners are responsible for making sure that anyone they lend their horse to is capable of properly and safely handling that horse. There was a 70-year-old man that went riding on Dennis Quaid's property and was bucked off of that horse when the sprinkler system came on. And that man said that it was negligent entrustment because he should never have been able to just ride that horse on that property, and that they shouldn't have let him do that, but without making sure that he knew how to handle the horse first. So he did not win that, but it's interesting the lengths that people will sometimes go to. So making sure that you're aware of their knowledge, their background, and trying to make sure that you're making good decisions based on that. As far as avoiding danger, so now we're talking about as far as accidents go, choosing the more dangerous of two viable options may actually reduce your ability to claim liability if you're injured. So horses on roads, if it is safer to stop the horse in the road versus getting off of the road because you're on a bridge, then obviously you have two options, but one may be more dangerous than the other. Tying horses in an unsafe manner, trailer loading methods, so loading horses in a trailer in an unsafe manner, anything that you can do that is a safer way, always opt for that, because you can be claimed deemed negligent, or they can put liability, the liability can lie on you if you injure someone or if you become injured even due to things that you do that aren't necessarily within industry standards. As far as equipment, so this again, horse owners have a duty to use and provide appropriate equipment for a given horse and tack. So you know what fits your horse better. You know your lesson horses typically, or even your own personal horse that you might be lending to a friend to ride along with you on your property. But you need to make sure that you get the right bridle with the correct bit in it. You need to make sure that you have the correct size girth, just because, you know, your horses gained or lost a few pounds. You know, you might need to consider just getting new equipment versus trying to make do with what you have. That equipment must be properly maintained. So depending on the type of equipment or the discipline that you're riding, making sure that your stirrup leathers are in good repair, making sure that you know, everything is solid and is accounted for, and that there's no chance that something would break. And then experienced horse people are expected to use tack correctly. But even if we expect someone to know how to do something, I teach college students, and you would be surprised at the number of college students who are embarrassed to tell me that they've never put a Western saddle on, or they've never put an English saddle on a horse, and they'll just try and tack the thing up. And then I'm like, your saddle pad is backwards and upside down. I don't know how you even got this girth on. You know, it's just very interesting to see what they'll do and not ask for help. And really, it has taught me that just about anybody will do the same thing. So just kind of keep that in mind. Coming down the home stretch, I've only got 3 more slides left. So I do have one case study, Cooperman v. David. This one was a gentleman that was riding with Wyoming River and Trail Guide, Matt David. And they had been riding, they had dismounted, they had had lunch, and Mr. Cooperman was getting back onto the horse. The saddle slid and he fell and injured his shoulder. So there they had to they had to prove that there was an inherent risk of the activities that he was participating in, and then also had to prove that the trail guide had exercised adequate duty of care. So making sure that that tack and equipment was safe and serviceable and sound for what they were actually doing out on the trails that day. So this was my favorite finding in many of these case studies. So the judge and the court decided that it was an inherent risk of the activity, because saddles are not permanently fixed to the horses, and so it would be expected that they could slide. So it was found in favor of the defendant, so Wyoming River and Trails, that guide, because horses don't naturally have saddles stuck to them. So again, that inherent risk situation played in their favor, so the inherent risk of those activities. And then finally, another thing we kind of touched on briefly earlier are as far as fencing goes. So there are lots of different laws by state, by county, by city even. If you have open range, you're trying to keep livestock out, you're trying to keep livestock in, or, you know, in a smaller facility where we're just trying to hopefully keep those livestock in. And what constitutes a lawful fence? And so we think of anything that is in good repair and that will keep a horse contained safely. Interpretation and interpretation of liability and negligence could depend on previous escapes. Is that actually a proper fence for the type of horse, the height of horse, and is the condition of the fence kept the way that it should be? Some states have, what they consider a lawful fence, either 5-strand barbed wire, paling and wire, or 3-wire plank or slat fencing. So there are some states that have very specific definitions of what is lawful. Accidental damage to or gaps in the fence, you can be held liable if you do not address that. So if a horse were to get out because your fence is in disrepair, then that could be liability and negligence. Also, gates, making sure that they're closed and horse-proof. I have a gelding that is a Houdini, and he can get out of just about anything. And so with him, I have to make sure that I have multiple methods of keeping that gate shut instead of just the chain that he has learned that he can lift and then push the gate open. Sometimes horses are too smart for their own good. And then here is actually a decently bad situation. So a lawsuit was filed over a car collision with horses on I-280. That was the headline. Dr. Jean Gillen, in 2012, her Mercedes collided with one of 4 loose horses from a nearby Webb ranch. So there was a smaller Toyota Camry that had hit, I guess, a couple of the other horses. And they were struck and killed. And then Dr. Gillen ran into one of the down horses that was actually lying in the slow lane when she came upon the accident. Serious personal injury, property damage, hospital medical expenses, loss of income, earning capacity, and household services. And she was paid $25,000 in damage, which and the damages that she was seeking because the fence was not in good repair. There was a tree that had come down across the fence, and the horses were not maintained on the correct side of the fence. And so she was actually awarded in that case. And that was a situation where the horses had gotten loose just because the fence was down. So again, you can kind of see how important it is to make sure that everything is in good repair. After all of these storms, I check my fence lines just to make sure. And then finally, kind of what I had talked about before. So anything that children or even adults, curious adults or youth can be drawn to or classified or referred to as attractive nuisances. And unfortunately, horses are classified as that. Those laws do vary by state, but making sure that you have a fence line that is going to deter someone from trying to get into your property. But honestly, a small child could squeeze through fence boards pretty easily and then be in the field with your horse. So as long as you do what you can, then you should be safe from, any kind of issues there. So I apologize for going over time there, Matt, but I'll take any questions if y'all have any additional questions now.
We've got a couple.
Okay.
This was very informative. Really appreciate you taking the time to do this. My question is, I have electric fencing and I've got warnings all over the perimeter of the fencing stating that it is electric. My question is, I guess you might have answered it, children and what about pets? I've got a neighbor dog that I have warned the neighbor that I have donkeys in that field and that they will chase and kill your dog, if the dog goes up under the, the fence, which it has pride. Am I held liable for damages to their pet if their pet were to injure?
Right. So you have a neighbor's dog that's coming onto your property and you're asking if you're liable for any injuries to that animal from your animals that are contained within your fence, correct?
That and about electric fences having signs if kids are coming up around that area.
Oh, yes. Okay. So the dog question is an easy question. I had an issue with my neighbors, same thing. And it only took my gelding having their dog pinned down to the ground and it, making the yike, yike dog sound for them to decide that it was time to keep their dog on their own side of the property. And I asked them if the dog was okay, and they said, yeah, she's fine, she's shaken up. And I had already had a conversation with them, multiple conversations on, please don't let your dog over here. My geldings are not fond of dogs, and your dog is chasing them. And in that situation, I am not held liable. You would not be held liable, even if your donkey were to kill that dog, because that is your property and they are failing to exercise a duty of care, and they are being negligent in allowing their animal access to your property, especially if you, even if you haven't asked them not to. That goes for anything. That's a situation where that animal should not be there. I'm sure that there are leash laws, even in usually sometimes the counties, that will state, that animal has to be properly and safely maintained. So nope, no liability on you there. They can try to come after you, but there is zero way. Now, I can't say that for sure. There is like a 99.9% chance repeating that you would not be found liable for that. As far as electric fences, that's great that you do have the signage. And at that point, that is going to be on the parent or that individual, even if it's a young child that, comes over and tries to go into your field through that fence. You don't even have to have it labeled as, how much voltage is on that fence. And really, you don't even have to have it labeled as an electric fence. It's great that you do. That's just an additional deterrent. But that's not necessary. But I mean, if someone, again, were to come onto your property uninvited, then that's not your responsibility. You're not liable for any injury that they sustain from basically doing something really stupid. So.
Thank you. We got.
So it's kind of a story, but it might be helpful. I had years and years ago a little 3-year-old boy across the street neighbor who got out of his house, away from his mom, came over to my property, crawled under the fence where I had a mare and baby. So no one knows exactly what happened. We were at work, and but the mom, who was pregnant, found the child lying in the pasture with the mare over him, and he had hoof marks on his back and head. So she gathers him up and they go to the emergency room and he gets admitted to the hospital. We get home from work that afternoon, don't know anything has happened. Dad went about our business the next day. She informs us of what has happened. And so we're kind of like looking at each other, and he's still in the hospital. So my suggestion is call your insurance company if something happens, which is what we did. A lot of what Lacey has said rang true. Insurance company comes out, basically takes a deposition from us, and they take pictures of the fence, health records for the mare. Is the fence appropriate? Is there any history of this mare attacking people? That kind of. The insurance company initiated with the family not an admission of negligence or anything, but they go over and they offer to pay all the medical bills, and they accepted that. They also let us know that the child had until he was 21 to sue us for, So I read the paper every year to see that he was making the honor roll. He was, he went to college, he's 21, and we still have a great relationship with his family. But, if something happens, call your insurance company, because they're the ones going to get involved anyway, eventually. And, but, it happens. Why were you nominated? I was not. Oh, you were not? No admission of negligence, but my insurance company, I guess, is good faith, just paid for the medical bill.
Wow. And Did you have any signage, or had that been a situation before where the little boy had kind of gotten out of the house or anything?
So that's, I didn't understand your whole question, but that's, did I have signage? Well, I have the liability sign.
Okay, good. And that even though a 3-year-old child obviously cannot read that, the reason that I ask is because that would then be in the photos that your insurance company was taking, and that proves that you have that understanding, you know, of what it takes to be a safe facility or to safely contain horses. So that, you know, I'm sure was another point in your advantage. And it sounds like exactly, you know, you did everything right and had everything the way that it needed to be. So I'm glad that that worked out. And I hate that happened, but then also for you to have that information to share with us this evening is good, just for others who might find themselves in the same situation or a similar situation.
All right, any other questions? All right, well, thank you, Lacey. We really appreciate it. This is great, very informative. And then if you're okay, if you will send us that document that you have, and then if we get any follow-up questions that maybe we can't tackle, if we can send them on to you.
Absolutely, yes. Please share my contact information. I just realized I usually have it at the end. But if you don't mind to share my email with anybody who's interested in or wants to follow up, I definitely encourage you all to reach out. And thank you so much for letting me be a part of tonight. I apologize again that I definitely went way over my time. But thank you for listening to me. And again, if you have any questions, please don't hesitate to reach out.
Thanks, Lacey. Have a good night.